if you move to exclude something in limine, just to take a simple example, evidence about the defendant's insurance coverage, and that motion is denied, the trial court says, no, Mr. Lewis, I'm going to allow that evidence at trial. You've perfected the record and you don't need to do anything else. You've made your objection. It was squarely overruled and you were set for appeal.
Yeah, you don't have to keep burdening the record and annoying the judge by continuing to assert that objection over and over again.
That's right. And in addition to doing those two things that you mentioned, highlighting evidence that is going to be admitted and heard by the jury for the jury.
So what happened with that motion in limine? Was it was made? What was the ruling on that motion in limine?
So there was a motion in limine, and it was essentially, don't let the plaintiff talk about anything prejudicial or unduly sympathetic. And the trial judge said...
Was it really that vague?
It was absolutely that vague. And the trial judge said, that's too vague to grant, but ended with language to the effect of, notwithstanding, any evidence or argument offered solely for the purpose of generating undue prejudice or overt, sympathy, essentially threw some adjectives in there and said, look, anything really, really prejudicial or really, really sympathy-inducing, you can't do that. That's prohibited.
And is that different from the state of law in Georgia, just as a baseline?
No. I don't know if California is a federal rule state, but I know that you also practice in federal court. That motion in limine is not really any more different than saying, don't violate federal rule 403. It is not. And as far as I know, in every state but Georgia, an objection to the death warrant argument would have been required. Even if the theory is the death warrant argument was unduly inflammatory and unduly prejudicial, and even if the trial court said we aren't going to be allowing that, I don't think there was a jurisdiction other than Georgia where a contemporaneous objection to closing argument would have been excused.
Yeah, maybe it actually would have been better for the judge simply to deny the motion in limine and say, look, defendant, you have to just raise your objections at the time that the evidence is or arguments made.
So there's a subtlety there, and I'm glad you asked the question that way. Had the ruling simply been motion in limine denied, that arguably would have preserved any objection to anything that would have been encompassed in that denied motion in limine. Now, the gloss you put on it, essentially the way you describe the trial court's hypothetical ruling is a deferred ruling. And a deferred ruling in Georgia preserves nothing. So had the trial judge simply said, this is too generic, renew your objection at trial, and stopped there, we wouldn't have had this appeal. But because the trial court went on to provide what I'm sure the trial judge thought of as helpful, common sense direction, that launched an appeal. And our Intermediate Court of Appeals actually reversed, despite the lack of objection, relying on a line of Georgia Supreme Court cases that said that if you bring a motion in limine and it's granted, you need not object to a violation of that motion in limine during trial. And that was what the Georgia Supreme Court, we entered the case after the Georgia Court of Appeals, our Intermediate Court of Appeals ruled. We entered it for the purpose of seeking cert and challenging this rule at the Georgia Supreme Court level. And that is what the Supreme Court accepted cert on.